Hello, everyone. We are live. Thank you for joining us this evening for the Discipline Matrix Ad Hoc Committee. Chair Garcia Costa should be joining us a little later, but at this time we will start the meeting at 6:05, and I will turn it over to Captain, Acting Captain. But
That's
yes, did I
right.
say
You
that?
got it. Yeah.
Acting Captain Brian Hubbard for the meeting. Okay, thank you.
All right. Thank you, Micah. And hello, everyone. Uh, I need to share my screens. Pardon me one moment. All right. Can you all see my screen there?
Yes, I can see it.
Great. Thank you. All right. I only had one task item, which was we talked about unauthorized subgroups. So this is under the umbrella of subversive organizations. So a couple weeks ago, about a month ago, maybe we talked about creating a section within it that talks about unauthorized subgroups within the Oakland Police Department. And we went down the rabbit hole of finding California Penal Code Section 13670B, which mandates that we actually write a policy on that and prohibit internal subgroups. I notified our policy and publications team about the need for us to draft a policy, hopefully sooner than later. That will definitely have to go through the commission and be agendized soon. So hopefully they'll pick up where we left off, and then I will also work in the background with that. But anyway, I was also tasked with modifying this manual of rules section to include that and also remind people about our policy if one is aware of these subgroups that they have to report it. So I'll go ahead and read the definition and we can make adjustments from there. So it's no member or employee shall form, join, participate in, or support any unauthorized sub-organization within the Oakland Police Department that operates outside the established chain of command or official departmental structure, engages in activities that undermine departmental policy, leadership, or legitimate operational directives, promotes loyalty to the subgroup over loyalty to the department and its mission, engages in or facilitates conduct prohibited by law, departmental policy, or professional standards, uses symbols, communications, or services that create a separate identity or allegiance apart from official departmental affiliation, or intimidates, retaliates against, or excludes members based on their refusal to participate in such subgroups. Members who are aware of unauthorized subgroups or violations of this rule and fail to report such information shall be subject to disciplinary action. Report shall be made per departmental order, general order of M3. And then violation of this rule is grounds for termination pursuant to California Penal Code Section 13670B. And then this prohibition does not apply to officially recognized employee organizations, labor unions, professional associations, and departmental committees or task forces authorized by the chief of police. All right, any questions on that?
Seems pretty complete to me. How about you?
Yeah, I feel good about it. I'm glad we got and this is the right section, the penal code section, and we're citing it. So
great. All right, great. Thank you. I have to make sure. Let me just make a note for myself here.
Does the law say gangs in it, unauthorized subgroups in the code?
Let me pull
it.
Because
if it does, fine. But if it doesn't, we should take that out because that may that has a bias tint to it.
Yeah, let me just see real quick. Yeah, it does. It actually defines a law enforcement gang, and it's in quotations, means a group of police officers within a law enforcement agency who identifies a blah, blah, blah. So it's actually the first section.
Does it say law enforcement gang?
It does. It says law. Yeah, it's actually in quotations. So that's the actual.
Yeah, well, then we ought to put law enforcement gangs. because we're not talking about being a member. Well, we are talking about if you're a Crip or a Blood, but I don't want people to think that these kind of subversive groups are only associations like Crips, Bloods, MS-13, blah, 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 blah. I'm not supporting them, but law enforcement gangs is what the original intent of the law is speaking to. Thank you.
Is this in place of unauthorized subgroups? So get rid of unauthorized subgroups?
I like whatever it says in the law. Let's place it in. What is the subtitle in the law say? Penal Code section 13670, subsection B, whatever it says, let's use that.
It doesn't really have a title. I'm looking at LA County. They put law enforcement gangs and hate groups.
That's LA County. Okay. I like that too. I like the hate group in it.
Can I make a comment? This is Commissioner Emeritus Peterson. Hello.
Hi.
Everyone.
Hello.
I just want to continue to caution you against summarizing law and leaving out, maybe inadvertently, critical words. So make sure if you're summarizing something that that at least you somehow indicate that the full text is found at such and such and such.
It's a good idea. So it's critically important to know what Penal Code section 13670, subsection B says, and use that language. And then do what Marsha's indicating also.
Welcome, Chair Emerita. I also would like to welcome Ms. Leonard. We didn't think you were coming, but it's good to see that you are here. I also would like the ad hoc to know that Ms. Asada is in the audience. So Ms. Asada, if you have a question, please raise your hand and I will unmute you at that time, okay?
So
good evening, everyone.
Good evening.
Good evening.
Hello.
So this is the manual of rules section. So basically it's going to reference then the policy that one can violate. So I would agree. I don't want this to take away from it, but I also don't want it to read as a policy. You know what I mean? Like 3 pages of what an MOR section is. It should be the policy clearly delineates what the penal code section says. And then this merely say, if you violate that policy,
yes,
then here's the discipline. So maybe to all of your points that maybe this is too broad or too detailed when it should just say, hey, if you violate 13670, be in accordance to this policy, you're terminated, I guess.
Yes, as long as you make it clear, if you're trying to summarize something, that it's a summary, and that the full text is found at such and such. Because if you start toying around with language that's been carefully crafted in legislation, and you leave out a word, or you leave out a word. I mean, these things are, shall is different than may, and things like that are just really important. So be careful of trying to reword it, and you think you're helping, but you're probably hindering the effort overall.
Right. Yeah, that makes sense to me. Okay, so maybe I'll pivot and I'll probably want to spend more of my time working on the policy to make sure that's dialed in. And then this one would be, yeah, something to refer to that. Okay.
I just want to put this on the table. I'm reading right now Penal Code 13670. And paragraph 2, that's what you're talking about, speaks to law enforcement gangs.
Right.
So the intent of this law is not saying gangs that the average person knows about, Crip, Blood, Hell's Angels, that kind of thing. No, they're talking about law enforcement gangs.
Yeah.
So, and of course, we're not denying that if you're a member of the Crips and Bloods or MS-13 and you're a Oakland police officer, that can get you in trouble too. But
Right.
this is about law. This is the intent. I don't want anyone to say, well, it doesn't apply to me. I'm not a Crip. I'm not a Blood. I'm not a blah, blah, blah. But I am a part of an organization that are men against women, police officers. That's a subversive subgroup. That's a law enforcement gang that this law was directed at.
Yeah. 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 You're spot on with that as I read this. Yeah.
You may even direct them to the penal code section and especially, subsection 2, which defines it. Like Marcia's saying. This, what you put up here, is just telling people to, not telling people, but telling police agencies develop a policy against this.
Yeah.
Right?
Right.
But don't we want to say, Penal Code 3670 is a criminal offense? Is that a criminal offense?
It is. Yeah.
Yeah. I'm
Well,
going to make
it
myself
doesn't-
clear.
Yeah. I understand.
I think Penal Code subsection B, it will throw us off, will make us think that what we want to do is develop a policy. We need, if we're going to have 3670B, leave it there. If you're going to have it there, you got to have 13670 subsection 2 and subsection B. You got to have both of those there so people can go to it. So I would have 130. Yeah, there you go. Yes.
Got it. Okay. All right. I'll rework this. Commissioner Rouse, has this come up in a commission meeting? This conversation or even OPD's need for a policy?
No, not that I've been at. No, it hasn't come up.
And that's just because we just didn't know about it.
Right.
Right. We
Well,
all got it. We all offended by it. Well, some of us are.
I'll bring it up again with the policy and publications unit, but it would certainly be helpful if it came up in a commission meeting. Then I know the task would be done. You know what I mean? Like it'd be a deliverable.
Definitely make that happen.
Okay. Yeah, I understand. So, all right, I will come back to this then. Okay, good. Last week we talked about these in green and we left off with the one in yellow, and we wanted to reconsider the range. I'll go over it again just to refresh our memory. 314.70. Use of privileged information. Members and employees are prohibited from using information not available to the public gained through their position as a law enforcement officer or within the department to gain financial or other benefit for themselves or another. We said right here that maybe this was a little bit too steep. So the first offense is a 10-day suspension to termination, and the second one is termination. So we wanted to address that today. 424. Let me see what they meant there.
Can we see what the current policy is right now?
So we don't have a policy on this, and I think that's the other challenge.
So so last week we said that the police department was dealing with this by either the officer who released private information of an individual would be suspended up to 10 days, or I guess at the far end would be terminated from employment. So
Yeah.
where does that language where's that language?
So it's not, and I think that's the weird thing about some of these manual of rules is that there is no technically a policy to support it. But I thought of another example. Let's say that there was like a city announcement on, let's say, the budget for the city of Oakland, right? And it's only privy to, certain personnel, including myself. And I then take that in public, I give it to the media. Say, hey, here's the budget in case you want it, right? I think that's privileged information. I don't want to cross a line of criminal information. That's a different category, but just say straight city of Oakland privileged information. And here I am giving it to the media. That is where this violation applies.
Okay, so I'm not so concerned about that. I'm more concerned. Let me give you an example. There's an officer involved shooting. There's never a mention of any past misconduct by a police officer. Say they've shot someone else before, they beat someone up before, or whatever the charge was.
Right.
That information is never released to the public. But any information about the victim, meaning a resident or a citizen, is released to the public. And I'm wondering, why is there a difference? If you're going to release information about the victim, then information should be released about the officer. And then I also gave the example of someone who was actually fired from a governmental agency for releasing personal wage information, salary information about someone they knew and were sharing it with a third party. And that person was terminated. So I'm wondering why the police department, who has access to so much privileged information and personal information about an individual, why are we releasing that information? And it's a 10-day suspension. I think it should be termination.
Okay. Yeah, I understand what you're saying. I don't know if I have an answer of why we do one and not the other. I know there's a different set of rules regarding protection of the officer's name under the Police Officer Bill of Rights.
Yeah, we can't. Yeah, that's
I,
the
Right. So we shouldn't be releasing that information about individuals either, members of the public.
So if I'm understanding you right, Kathy, you're saying you're not even arguing against the police officer's Bill of Rights. You're saying if you're not going to let that go, that information out on police officers because you're prohibited by the police officer Bill of Rights, then Oakland, you shouldn't taint the public by releasing historical information about the criminality of a suspect.
Right. But I'm not saying that I don't have concerns about officers being covered by that Bill of Rights, because I believe that any harm that they have committed against the public should be released. We should know about who is coming out on calls. We should know if an officer is a bad officer.
Yeah,
We
but
know if he has some sort of activity which would be harming members of the public.
what Government Code 3300 prohibits.
Oh, I know. I'm just saying that
Yeah.
I'm not in agreement with that. I know that it's prohibited information, but I think that that OPD should not be releasing information about individuals either.
See,
Police officers are no more special than citizens.
but they are under Government Code 3300. I'm not saying that this is not doesn't feel unfair. I'm not defending this, but Government Code 3305 says, and I'm quoting, no public safety officer shall have any comment adverse to his interest entered in his personnel file or any other file used for any personnel purposes by the employee without the public safety officer having first read, signed the instrument containing the adverse comment, indicating he's aware of the comment, except that such entry must be made if after reading such instrument, the public safety officer refuses to sign it. Should a public agent refuse to sign, the fact shall be noted on the document and signed or initialed by officers. And then it goes on to say something about names and protection of a public employees' names and file, prohibiting it from being made open to the public.
No, I understand that. I understand that. But what I'm saying is that by OPD releasing information about a victim, you're tampering with the jury pool. You're tainting the jury pool, a possible jury pool.
I agree.
And so now that if the person is arrested for whatever reason, they're not going to get a fair trial because the possible jury members have already heard negative information about a victim that they cannot erase from their minds. I like when the judge says, strike that, the jury won't pay attention to that. It's already out there. Of course you're going to pay attention to that. So I'm saying the members of the public should be protected as well.
So isn't this a shooting of a police officer? Isn't this something that would go to the district attorney and the courts? It's not something that the police officers should be releasing to the public. Isn't that right?
Yeah, but they do release information. That's the problem.
Well,
So there should be some rule as to the department releasing this information outside of the requirements of the district attorney's office.
Exactly.
the problem here, though, is that there is the legislative protection of information being released on police officers and citizens. If we want that kind of protection or equal protection of citizens who are engaged in these kind of situations, that's a legislative piece that we need to advocate through our legislative representatives. I understand it's unfair.
Yeah, I'm
For
with
sure.
Well, that may be, but I still think that there should be some punishment against an officer who would do something like that. And nothing prohibits us from exacting some sort of punishment.
Well, you're assuming that that information is released by an officer, right? And that's not necessarily the case.
Perhaps it isn't, but what about the case where it is, where an officer has released that information?
Yeah, right. Yeah, and I agree with you in that circumstance. Let's say I just decide to post it on social media or something. I would argue that that's privileged information that I should not release. I agree with you.
But if it comes, are you arguing that a police officer individual, or are you saying the department shouldn't release?
Individual.
Both. We're dealing with individuals here. So this discipline matrix doesn't go to the department, is my understanding. It's individual
Right.
officers, correct?
Right.
So
Yeah.
for our purposes, individual officers. Now, you have to prove that an individual officer did it, but if they have done it, there should be some punishment more than 10 days of suspension. I don't think that's a deterrent. In other agencies, if when I was employed by someone, I have my own company now, but if I were employed by someone and I released private information about a co-employee, I would be terminated. There wouldn't be a warning. It's understood that that's something you don't do. That's crossing the line. And police officers should be held to that same standard. And it maybe another day, we can deal with the police department as a whole releasing that information. But right now, we're just dealing with individual officers.
I would agree.
This would be a lot easier if I had recent examples. When preparing, I usually try to see, okay, what's our history with this and what have we done? I couldn't find anything in recent history, so it's hard for me to.
Well, it may be something that has not been noted. There may be no records relating to an officer who's done something like that. So I'm saying, since we're here today, that's something that we need to address. So if it does arise in the future, we will have it covered.
Okay, so what I'm hearing then is the first offense should be just termination. Or do we want to have a range in the first offense that's a little bit more severe, starting with the 10-day suspension, or should it be a straight termination?
So when officers are trained, are they trained not to release personal information and criminal records of victims or defendants?
Yes,
Okay, so then they know that that's a duty,
it
that they
is.
don't release that information. And this is so sensitive. This is why a lot of people don't trust the police. And if we're trying to move towards the parties being able to trust each other, or the community being able to trust the police department, then I think that we ought to be serious about exacting some sort of punishment that is more than a 10-day suspension.
I-
That officer can go on vacation. Yeah, I needed a break anyway. But I just feel that that's a weak response to something that is so heavy.
Right. So I'm thinking of the examples that are not personal. So I understand, and those are definitely aggravating factors of personal information, or it can put someone's life at risk. Certainly, that's an extreme example. But what about just privileged information that there's no individual victim? Let's just say that, hey, the city of Oakland gave me this information. I should not have put it out on my social media. Is that also termination?
I guess it depends on, I'm trying to think, like, give me an example.
Yeah, so let's just say again, they produced the draft budget for January 1st. And it's like, oh, that's interesting. Let me send this to a friend of mine. So it's privileged information that I'm giving to someone.
Right, but it doesn't harm anyone. It doesn't harm a member of the public.
Right. But I'm saying if we don't have a range, though, we're saying that's termination. That's where I think the range comes in. What the previous example you gave is great about personal information against a person, highly inappropriate. The chief now has, and the commission now has, the discipline committee has a range to work with. They can say, you know what, that's severe, that's termination, versus the budget example where it is privileged information, but not as severe. We want to go as low as 10-day suspension. That's the reason for the range.
Right.
Yeah,
So
I don't
I
think
think
that's.
I think when we spoke last, we were someone, I think maybe you and Reginald gave the example of no harsh punishment for a favored homicide, a very good homicide detective. You want to keep that guy happy, so you don't want to get rid of him. You don't want to exact any strict punishment or severe punishment against that person. So then we get into equal treatment. Because if a person isn't a favored detective, they may get a severe punishment, and the person that is favored may not.
Right.
So we
Yeah,
have to
that
make sure that it's some equal application of the punishment.
yeah, for sure. Yeah, you're speaking of task 45, which is still an open and out of compliance task, and that's the discipline disparity.
Right.
And yeah, and you're right. And I think to your that's where this matrix, that's where this team comes in. And when we're presenting discipline to the chief, we look at 5-year history, we look at mitigating aggravating factors. It's not just you put your finger up in the air and say, oh, today I feel like a termination, or today I feel like a 10-day suspension, or this is a great officer, we shouldn't do that. That stuff is highly regulated, and there's a lot of interested parties in that when we have these meetings like we have every Wednesday morning, uh, where that's a big red flag if that did happen.
I'm sure that happens. I mean, the Black Officers Association was leveling some claims against the department,
Yeah,
and I believe that was one of the allegations against the department,
yeah,
unfair treatment. So it certainly happens.
sure, sure.
So the question is, what does everyone think the punishment should be?
So the question is just termination. No 10 days. One time is done. You're suggesting termination.
If you harm an individual, yes.
Okay.
So an option here is, this is where we can create a class 2 category, right? So we can say class 1 severity is a termination, but class 2 is everything else, where yes, you shouldn't have released that privileged information, but there was no harmful outcome to a person, or let's say bringing disrepute to the city. We can create a class 2 so it's less severe. That's an option.
Let's do that.
Yeah, I like that.
Okay. Great. Let's see. I like that too. Let me just put a note for me. Class 2 less severe. And Kathy, to your point also, it's like I'm somewhat surprised we don't have a policy on it, because I remember looking into this after we brought it up last week, and the example of an officer involved shooting where we released information about the victim, then it's by our public information officers, and I don't know if there's guardrails there. I mean, they know what they're doing, but I don't know if there's like a policy that actually establishes that. So
So we're saying, so a class 1 would be, let me see what you're going to put.
person with severe
Release of information which harms an individual. Should we say not only an individual, but a class of individuals
yeah.
as well?
Can't spell today. Okay, yeah. All right. There's a closely associated section that I know we already addressed, but it's along the same lines, where there's see if I can readily see it here. There's improper dissemination of information, but also this one, unauthorized use of electronic systems. Those carry different weight also, but I have a, if I access criminal databases to get personal information on someone, and it doesn't even have to be released, it's just me accessing the database, that is a criminal offense. That's how severe it is.
Okay.
So the way that can stack up is that I unauthorized access to the system, obedience to laws, and then if I disseminate it, then that's a third aggravating manual rule section. To Kathy's point, very severe.
So these two, what is the range on these two? Unauthorized use of electronic systems and improper dissemination of information.
It goes from counseling and training all the way to termination. That's it. We'll come back to this because it's a pretty wide range here.
Okay, we're not there yet.
Yeah,
Okay.
we're not there yet. We're going to come back to it because some of these get a little confusing, but it's anyway, I'll come back to it. I'm going to trust my memory and I know I'm going to fail. So I'll
Can I offer something? I don't know if this helps, but I do remember, Kathy, your unreadiness. I remember that unreadiness became a part of California legislation, and I remember something about the broadening of the disclosure of a police officer's records and behavior to the public.
Yeah.
So they're under Penal Code 832.7. This is just for your edification. Under Penal Code 832.7, any use of force causing death or great bodily injury, any sexual assaults involving a member of the public, any dishonesty in reporting, investigation, prosecution of crimes, and any on-duty dishonesty or perjury. Those 4 elements under 832.7 can be disclosed. So
that's right.
So I don't even know if does the Oakland Police Department follow that.
We do.
Okay.
We do. Yeah, we have to disclose it. And then also, like, we have a very robust system where we have to disclose it to California Post also for decertification consideration.
Okay.
We do that just on the mere allegation.
Okay. And so does the public know it?
They do. I mean, I know we advertise it at the time that, yeah, and they do. And there's an actual website where you can go and see all of this.
Excellent.
Yeah.
So this is edification for all of us in Wilson and so.
Thank you. I'll look at that code section later.
832.7.
Okay, thanks. 832.
Let's see, I want to look at trying to find the website here. If you go to, I can send you all the link. How about that? It's
Oh, can I ask for clarification? Was that the government code or the penal code?
That's what I said was the penal code.
Okay.
But the police officer bill of rights, that's government code.
Right. Okay. Thanks.
let me just copy this link down because I'll forget to send it. Okay. All right. Very good. 314.73 other transactions. Members and employees shall not use their authority or position to purchase, convert to their own use, or have any claim to any found, impounded, abandoned, or recovered property, or any property held or released as evidence unless specifically authorized by the chief of police. That first offense is a 5-day suspension and termination. The second offense is termination. An example of this is during sideshow. Let's say I tow a vehicle and it's a vehicle that I have an interest in, and let's say that the owner never recovers it after the hold. Say they abandon it, and then here I am purchasing it at the auto impoundment lot. That's a very extreme example, one that I cannot cite as a real one, but it's an example.
I remember an example where officers would take drugs from a drug dealer and then use them in undercover operations. And so what would be the punishment for an officer who did that? Or use it for their own use?
Well, for their own use, they got problems.
Yeah.
But but if they use it for an operation, that may be possible.
Yeah.
But I can tell you one that goes way back in
I know,
history.
even that seems like it's not right.
Well, I would frame that as dangerous to redistribute drugs like that. You're supposed to make fake drugs for that type of situation, and then it's dangerous for everyone. So that's one. But I'll use an other example is similar for asset forfeitures, right? So is it like, am I seizing assets to then turn it into personal gain, or am I redistributing to the city inventory, let's say, and use it for better gain for the community, right? So personal versus professional. There are regulations regarding civil asset forfeitures and how it can easily be abused.
Sure.
That's one, but anything personal that would fall into this category.
It's the infamous Joe Rudy case.
What's that?
You guys remember the Oakland A's left fielder Joe Rudy?
I don't remember that. What happened?
Yeah, OPD seized a drug dealer's Porsche and impounded the Porsche, and then the Porsche was went out to the lot and was to be auctioned, and Joe Rudy was tipped off, and he ended up purchasing the Porsche for a very, very low price. Nobody else knew that Porsche was going to be out there for bid, so he ended up buying, and then it was uncovered by what's the journalist that was killed? Used to be the Oakland police.
John
Bailey. Yeah.
Derwin.
Yeah, Bailey. Bailey uncovered it and wrote an article about it, and Joe Rudy had to turn the Porsche back in. That actually happened.
That's all that happened. He had to turn it back in.
No, it wasn't. Oh, you think like he should have been arrested or something? Or prosecuted?
Well,
not at all.
Something should have happened. There should have been some punishment.
There was none. He just turned it back in. Well, how did he get tipped off? How did he know it was coming up that day to be auctioned? And that's the kind of stuff that's why what we're doing now. It's trying to prevent that kind of loose government.
Would you argue that that's privileged information? Would that fit?
Yeah. Yep. They never found out how he knew. He never said anything. He just returned the Porsche.
Actually, that would harm members of the public, because if the car is being auctioned off, then the money would go to the city's general account, correct?
I don't know how that works, because it's the tow yard. I don't know. That's a good question.
If it goes to the city, then you are harming a class of people, which would be citizens.
But all of that is different from asset forfeiture. Is that what you were saying, Captain Hubbard?
It is. Yeah. I mean, asset forfeitures are on the up and up, where they're supposed to be. Like, there's disclosures and it's regulated, as opposed to, oh, this looks like something I can use for work. Let me seize that. And, that's, yeah. Okay. So going back to this, how do we feel about this range? 5-day suspension, determination for the first offense, and termination for the second.
Sure.
I'm comfortable with that.
Okay. Great. All right. 32807, prohibited activity on duty, sexual activity. So this one, just so you know, is specific to sexual activity. So there's a lot within this. Those have different sections. So we're just focusing on the first one. Members and employees are prohibited from engaging in the following activities while on duty: sexual activity. So that one is a 2-day suspension and termination for the first offense and termination for the second offense.
So of course I'm thinking about Celeste Guap.
Yeah.
And I'm wondering what the punishment was for those many officers who engaged in sexual activity with the minor, which is really pedophilia.
Yeah.
And she was 17 years old, 16 and 17 years old. What was the punishment for those officers?
I don't think anybody got punished.
That's what I'm.
No, there were some terminations out of it, and that one is more obviously more severe because we're talking about a felony offense. So it'd be obedience to law's felony. I mean,
Oh, I don't even remember hearing that any officers were
I
terminated.
never heard that.
yeah,
And see, that's that shroud of secrecy. The public should know that.
yeah.
Was this before, 2019, before they, set up that file for officers who can no longer apply to other agencies?
Yeah.
That was before then. Okay.
Yeah, so that raises a question. So if you're terminating an officer for pedophilia, which it really was in that case, would they be decertified?
Oh, yeah. They
Yes.
should be.
Yeah.
So those officers that were terminated were decertified?
No.
Well, some of it's retro. I mean, no, and they're not. It's just, I mean, chances. I from what I know, no one else got another law enforcement job after that, and it's hard too when these agencies do have background. But the
Yep, some of these agencies are hiring officers with criminal backgrounds, and so that's why I'm concerned that they don't get decertified. They just go to another department that really doesn't care, and they get hired. And then they repeat that same behavior again because there was no punishment. I mean, if you get terminated, you figure I'll just go to another department.
right. Yeah,
I think that an officer who's accused and who's found guilty should be decertified.
Yeah, that's certainly the case now. Certainly. The
Okay.
transparency and disclosures laws for sure. And if this happened today, what would happen is California Post would decertify them and their name would then be on this public website. So these agencies then could not hide behind they didn't know because it's on this website now where that would be then open to the public.
So is the Oakland Police Department mandated to report those type of illegal activities to Post?
Yes.
We are.
Okay.
We are. Yeah, and actually California Post, they also do regular audits now. I mean, there's been some issues in the past 5 years regarding this. So they regularly come in and do audits on backgrounds to ensure that we are ensuring that this is not a police officer from a different agency that got fired for similar activities, and here we are hiring that person. So
Right. Yeah. I guess I look at too much that ID channel, investigative discovery, where
Yeah.
officers have committed wrongdoings, and sometimes they're jailed. They're actually jailed. But yeah, so that show kind of brings to mind questions that need to be answered in my mind.
yeah, for sure. And yeah, you're not wrong. And I would say that we have, as a state, improved significantly in the past 5 years alone with new laws. Yeah.
That's good to know.
Now all those officers could now just go and work for ICE now, Kathy.
I'm
Ew,
going to say
you-
the same
Right.
thing. ICE doesn't care.
Have you seen those Homeland Security commercials where they're like, attention law enforcement, are you tired of following local rules? Are you tired of so much oversight or something like that? And like, if you want to fight real criminals, come join ICE with no rules. Like, it was just like totally pandering to like any cops that didn't want oversight, didn't want rules, didn't want any of that stuff. Like, just come be a wild renegade cowboy with us. You'll be
Well, I
accepted
think
here.
True. I mean, I saw two ICE officers on TV. I guess it was on the news, pulling a woman, manhandling a woman, and getting her out of her car. I thought it was just the worst. The worst.
Yeah.
Apparently 4 officers were terminated in the Celeste Guap case.
That's right.
They're zip tying babies now, so anything goes.
Well,
So
back to this particular case, I kind of think 2 days is a little low.
first, yeah, okay.
Because what we want to do is not, we want to make it strong enough that you don't do it the first time. So it should be, you know, it should be at least the same as releasing privileged information.
So a 10-day suspension?
Yes, sir. That's my suggestion. I would like to hear from other people what they think about that.
You know,
Yeah,
that's just
I would
that,
agree with you.
you know, that's so personal. Sexual activity and
On duty.
on duty and raping women, telling women, you know, I won't give you a ticket if you have sexual activity with me. I mean, that is just so personal that 10-day suspension just seems so mild to me.
It
Well,
is.
well,
Under that example, it
A really
is.
horrible thing that someone would do to a woman. It's horrible.
Yeah.
No,
I
I'm not
think
talking
if we-
about raping somebody.
Yeah. If we look at the Celeb Guap case, that would fall under more severe MOR violations.
Exactly.
I would imagine, right? This, and just to be clear about this sexual activity, is this like looking at porn on a computer or sexual or consensual sexual activity with a fellow officer? I mean, what is
or
having a
two
girlfriend over at your station and you're
or 2 officers who are married
Yeah.
that run off at lunchtime to, you know, and sneak off duty, you know, that kind of thing.
Okay.
Right. So if you look at like kind of the general theme behind this, sleeping, loafing, idling, conducting private business, the idea behind this is we're not committing crimes. This is all consensual. This is
just not
you're
appropriate.
supposed to be working and instead you're doing this. Now, please keep in mind the following. What Kathy says is absolutely correct. If I'm leveraging my authority to get someone to sleep with me, that's color of authority. That's a crime. That's number one. If I am doing it in public, even if it's consensual on duty, that's a crime. Okay. So there's other criminal things that we can go. Let's just take it for what it is. Like I'm married to someone here and we decide to go home on duty.
Right.
That is what this is talking about.
Right.
So then do you want to say consensual sexual activity to differentiate between non-consensual activity?
I don't want it to assume then that non-consensual is okay here. I mean, it's just sexual activity. I mean, I know what you're saying. I think people know, or they should know, that if you cross the line into criminal activity, this is a meaningless category. We have far bigger problems that we're going to deal with, which is obedience to laws and criminal charges.
So you're saying that sexual activity covers consensual and non-consensual?
Indeed.
Okay.
And you know, in my career, I've had 2 cases like this. You know, and you'll be shocked. There was one guy that was parking his police car behind a hotel, and having his way with an informant, and it was consensual, but the tourists looked out the window to admire the landscape and got a full view, and it wasn't even nighttime. You know, so yeah.
I would argue that is a crime because of the publicness, but publicness of it, but also borderline color of authority. If you're especially dealing with an informant, that is, I can make that argument as the IAD commander.
That's exactly what I was going to say.
And then there was a little choir practice, and then a couple went out to the back seat of the car, had their way behind a Mexican restaurant.
Yeah.
And people walked by and saw all that. They were, one of them was on duty.
Yeah.
So, you know, this is a necessary bit of prohibition, and I just think it should be increased to 10 days minimum, to 10 days to termination.
Yeah, no problem. I understand that, and I certainly believe that would be a deterrent. I'm going back to the original, maybe someone asked about like looking at pornography. There is a different section that would apply, but I would say, if I don't want to be graphic here, but if there's something included with that observation or what's going on, then that would fit into this category too. And I
Yeah.
would,
Because the first thing I want to say, what kind of pornography?
yeah,
If it's child pornography, you know,
different.
somebody needs to be arrested.
Sure. Sure. Okay. I like it. All right. So I'm gonna leave it as S10 to termination for the first offense, and second offense. Are we good with termination?
Sure.
Okay.
Yeah.
All right. 32853-1, false reporting of illness or injury. Members and employees shall not feign illness or injury, falsely report themselves ill, or otherwise attempt to deceive the department as to the condition of their health.
Okay, so now this, for me, this raises the question as to, is it my understanding there's about 80 officers that are out on medical leave?
Correct. That's right.
And so how do we know that they are still, that they still are suffering from an injury or illness?
Yeah.
I mean, a doctor's letter is one thing, but, you know, if you know your doctor, maybe he'll, you know, exaggerate a bit on your illness or your injury. So is there any, like, checking up on these officers? I mean, 80 is a lot of officers out there. So are we checking to make sure that they're not, um, uh, they don't have other jobs that they're working at while they're saying, so they're basically collecting two or three checks?
Hmm.
Or are we just taking their word for it that they are continuing to be ill or injured?
Well, I have a question in that regard. Are they on workers' comp? Is that why they are out? Or are they
Yeah.
out because they have an extended illness not related to the job?
It could be both.
It could be both under this.
That's right.
So I know that in workers' comp, you do the sub rosa process where you're checking on them. The word I want to say is kind of secretly, but you're watching them in a way that they are not aware. And
Yeah.
so they say that, you know, their back hurts and they're out playing basketball and
And
doing
golf.
layups and what have you. That's something that would render them, I guess, in not able to get their workers' comp, right?
That's right. Yes.
I haven't done that work in a long time. So at the end of the day, what are we trying to do in this particular provision?
Okay. So let's, if I can start incremental, because I know we talked about this before. Let's start with the very basics. Brian Hubbard calls in sick tomorrow. Okay. And it's just a sick day. I'm not hitting off on extended leave or sorry, I'm not claiming an injury. I'm just saying Brian Hubbard is sick. And my boss happens to see me at the movies or doing anything that I shouldn't be doing while I'm not sick. Okay. That's part one to this. So that's one, is like, you called in sick and you're not sick.
Or whatever you're saying. If I say my back hurts and I don't come to work, but I'm at the movie,
Right.
and I took Advil.
That's right. Yeah. It's very complicated. And California has very protective laws for every worker in California. It's very difficult, if I can put it frankly. And the comment about it's also easy to get a note from a doctor.
That's my point exactly. And if you take an Advil and and you can go to the movies, then you can show up at work.
I mean, some would argue maybe against that also for many reasons. I understand. I get it. I will say on the flip side of this, if we want to talk about workers' comp fraud is something that is commonly investigated and taken very seriously by the state of California also. Okay, so now I can give you examples of this just in my close to 30 years now working here. We've had that. We've had people who are claiming injury, and then next thing we know that they're posting things on social media of them doing activities that go against what they reported in their injury. We have been notified by workers' comp that they did their own investigation and people have been fraudulent there. We have done integrity tests on people who have been on injury and it was not accurate. So the question is, do we regularly check on them like as in a cadence? No, but we do have a medical unit that closely monitors this, and they do require regular check-ins from the member and also their doctor to confirm that that things are progressing or not with their health.
After 3 days, don't you have to, in order to come back, you have to have a doctor's note?
Yes.
Okay.
It's just weird, and I COVID kind of changed this where one can easily, you don't have to go to the doctor's office anymore, right? You just have like a phone consultation with your doctor and hey, like, oh, my shoulder hurts. Can you write me a note? Sure, no problem. It's not terribly difficult. So that's the other challenge.
Yeah. And you've got some unscrupulous doctors who play that game.
Indeed. And there's
I'm
ahead.
not so much worried about an officer who calls in sick one day and he's at the movie. I'm really concerned about seriously taking advantage. Well, you're off for a year.
Oh, no.
Now, like for instance, I'm going to give this example. The officer who didn't report, it was two of them. He and his girlfriend, who was also a police officer, didn't report that accident at the San Francisco condo. And then he fired a gun in the elevator. And is he still on medical leave? A year after that incident, he was still on medical leave.
Yeah.
This guy didn't report an accident. I'm just wondering why he's even still an employee.
I see, and that's culture. That's the city of Oakland's culture is not just limited to the police department. It's all throughout in
I'm sure it's in every
all
field.
throughout the city of Oakland.
Yeah.
People are ripping the city off. What Oakland needs to do is establish a fraud unit on its own and get out there and investigate these people and put some money into an attorney and prosecute some of these folks. You're going to change the cultural dynamic of the city. 80 officers off? That's obscene.
Well, it used to be worse, Reg. It used to be they thought it was okay because they were waiting for their skelly officer of their choice. And they were out for weeks, if not months, with pay. And we addressed that. Didn't you address it? I'm sorry, are you captain or are you lieutenant?
Captain, but Brian is fine too. And yes, we did.
Yeah.
Yeah.
And I'm glad you guys did. But in order to change this cultural dynamic in Oakland, we got to take some bold steps. We
really do. I mean, we're in the middle of a deficit. I mean, we balanced the budget, but we still have major issues because we had to close down departments, not fund certain things in the city that needed funding, and so 80 is a lot. And when that number starts climbing, I'm just concerned if every officer that is out, if they are still as ill as they say they are, or as injured as they say they are, and they might be. But I think there ought to be some way of verifying that. Other than, I remember a guy that I went to school with said that he was injured. And the insurance company followed him around and saw him jumping over a fence when he said he could barely walk. So, I mean, it's things like that. And it seems minor, but, when you're talking about a lot of employees, that's a lot of money because the
Oh
city
yeah.
does pay into um, workers' comp.
And if you talk to people who get citations in the city of Oakland, the way the city relates to people who challenge the citations they get is unbelievable. I got my car stolen. The guy who stole my car in Oakland got a ticket while it was stolen. My car was recovered. When it was recovered, I got a ticket saying I didn't pay the ticket, so it was a couple $100. And so I went down and told him, hey, I didn't have the car at the time. It was stolen. Well, you have to prove it. So I gave him the CHP recovery report, had to go down to Oakland Police Department on the 3rd floor and get the police report that was taken by a sergeant, turned all that in, and they said, well, we'll get back to you in a month. Well, they got back to me in a month. Yeah, a couple of days ago, I got a letter saying, we're sorry, you have to submit an Oakland Police Department report. I did do that. So I got to go back and do it again. So
So you're saying a sheriff's report wouldn't have sufficed?
the recovery report was by the sheriff's department. Alameda County Sheriff recovered the car, but the Sergeant Navarro, who took the original 10851 report, his report was submitted in Oakland Police Department. I had to submit his copy of his report, pay for it, and submit it, and I did. And but the ticket folks there on Clay Street said, "Hey, you got to submit the report." I'm so glad that I got a copy of all of that.
Right.
Now I got to come back again and submit it a second time.
Wow.
And I think what drives that kind of stuff is the lack of money. We want money. We got to get this money.
That's terrible, Reg. You should file a complaint somewhere.
Well, with whom?
I said somewhere. I don't know.
Yeah, I know. Well, I thought the captain would step up and say, well, you should try this.
Yeah.
Everywhere I go, they go like, well, that's the way we do things. Oh my God.
No, then you have to take it to court. Fight the ticket.
Chair, I saw your hand up.
Right. Yeah, I'll save my thoughts for right now. Thank you, though.
All right. Okay, just going back to this again, 32853. This one's severe. The first offense is a 30-day suspension all the way to termination, and the second offense is termination.
I think that's appropriate.
Yeah, I would agree.
Got to be a deterrent.
And that's 30 days of unpaid?
Correct.
Yeah.
Yeah, and I know we're mixing things up here. This is not people on administrative leave. I understand the whole Skelly thing, pending termination. That's different. This is just straight medical leave, who have a doctor's note, who then hit off on injury.
I guess, Captain, where I was thinking about was, I was trying to figure out how to best ask this. I mean, I've heard accounts, and not necessarily within OPD, but with other police departments, where there'd be a practice where one officer will call in sick, and then the other officer will cover that shift at maybe a higher rate or overtime.
Yeah.
And then the deal was, then I'll call in sick and then you cover my shift. And it was like this kind of like game that folks were playing. How do you get to the bottom of that? And does that fall under this category? Or is that a more serious MOR violation?
It definitely falls within this, and we get around it by our risk management meetings. I don't know you've been part of those before, but misuse of sick leave, or I should say misuse, high sick leave use. It's an indicator that we have in our assessment system, and we investigate further from there. I don't want to always treat it like it's a nefarious act. Sometimes people calling in sick is a product of someone having some serious mental, emotional issues,
Mm.
or because of part of the job. And those interventions have proven to be successful, where someone just merely said, "Hey, are you okay? Is there something I can do for you?" And then that's where these emotions come out. So it's not a misuse. It's just there's something more deep, but they come up in the risk management meetings, and I found them to be very impactful.
Great.
Yeah. Okay, so I think we're agreed on S30 determination and termination, so we're good with that. Okay, consumption of intoxicants, 32863. Members and employees shall not at any time be under the influence of any intoxicating substance while on duty, carry any firearm while consuming or under the influence of any intoxicating substance, consume any intoxicating substance while off duty to the extent that when reporting for his or her duty assignment, the ability to perform their duty is impaired, or consume any intoxicating substance while on duty unless necessary in the performance of a police task, and then only with this specific permission of a commanding officer and never in uniform.
So that last one would be an undercover officer or something?
Correct. Correct.
Pretty self-explanatory, yeah.
Yeah, so this 32863 S2 determination for the first one and termination for the second one.
I'm sorry, what did you say the lower end was?
Suspension, 2-day suspension to termination. That's for the first offense. Second offense is termination.
Did we
Wow,
jump over
What?
physical fitness?
A lot of 2-day suspensions, these lower end
Yeah.
suspensions. I mean,
Agreed. What would be an example of like you were drinking, but it wasn't so bad that we're only giving you a 2-day suspension versus a termination with a range that wide? Like what would be an example of something that wasn't so bad that would be considered on the lower end if we're starting, especially if we're looking at progressive discipline versus
Yeah.
Yeah.
Yeah, I don't think it necessarily termination would have to do with one's blood alcohol content, but I would say that it's probably attached to something else. Like let's say I come into work so drunk that I start vandalizing the place or pick fights with employees and all these other so that would be probably more towards the termination side, especially if it's attached to other things like workplace violence or even sexual harassment for that matter.
Gotcha.
Yeah.
So maybe an example of I'm just trying to think of like an example where we would consider like a T2, right? Maybe a colleague reported that his coworker smelled like alcohol and was drunk, but turned out it was just a long night, wasn't affecting his job duty, he wasn't doing anything erratic, nobody else noticed. But at that point, what happens? Do you guys do a breathalyzer? Do you guys like how do you prove that they were drinking in that moment?
Sure.
Yeah, and unfortunately, we've had these circumstances. We want to be unbiased, so we actually call for an outside agency to come in and do the investigation. And we have, and it's been successful.
Got it. So let's say scenario that the blood alcohol level is really low, and the guy was like, "Hey, I just had a long night. I'm sorry about that," type thing.
Yeah.
Then that would be like one of these ones we would consider a 2-day suspension, something on the lower end, I would say.
Sure.
I mean, I guess I'm just trying to wrap my mind around it because in my mind, immediately I was thinking, well, if anybody shows up to work drunk at any point, like, hey, that should be starting at a pretty high
But you're not
standard.
drunk if you're not are you, well, let me ask the question. Are you drunk if you don't if you pass the breathalyzer examination for driving? Do we consider someone what is the attitude in Oakland Police Department, Captain Hubbard?
I mean, to me, it's the title is consumption of intoxicants. So if it's in your system, then if you're displaying objective symptoms, I should say that is enough for me. It's not about being 0.08.
Right.
It's just
Right.
Yeah.
So this is the time you should have hit off sick.
Yeah, that's right.
so if you smell alcohol on someone's breath and they have been drinking, but they're not impaired, is that where the 2-day suspension comes in?
I would say yes to that. Yeah.
So
So
Yeah.
So don't we want to encourage officers not to drink at all? And maybe the suspension should be more than 2 days?
Sure. I mean, I think we certainly want to be a deterrent, but we also want to give flexibility though for the decision makers of the discipline. And that's where mitigating, aggravating, having a range is helpful. I will say suspension to determination is a pretty long range though. And if we're starting in the middle, let's say from a 17-day suspension, you know, it's going to be heavy. The way we weigh these things is we don't start on the lower end. We start in the middle and mitigate or aggravate from there.
Is there a reason? Did we do physical fitness for duty?
Not yet.
Wait, so say that again, Captain Hubbard?
When we do discipline hearings, what we've done is excuse me, is we start in the middle. So let's take suspension to termination. So the example is Brian Hubbard showed up to work drunk. Okay. We don't just automatically say, well, he only showed up drunk. He didn't do anything. We'll start at S2. What we do is we start in the middle. So let's say the middle of a 2-day suspension to termination is about 17 days. Then what happens is you mitigate or aggravate. So the mitigating factor, let's say, is we caught it right when he came into work. He didn't drive to work. He didn't, no one was harmed by this. He didn't make any critical decisions that puts the public at risk. Let's mitigate down from 17 days. The aggravating would be he came into work, he was belligerent, he was hostile, he embarrassed us, he blah, blah, blah. That's aggravating up. So I don't want you to think when you see this range of S2 determination that everything starts at the bottom and works its way up. It doesn't work that way. We always start in the middle.
Although that practice is even now up for discussion as well.
It
at
is.
some point, we
Yeah,
may look at that. Yeah,
it is. You're absolutely right, and it's not codified. And I think that's the biggest hang up right now is it's like there's no policy on the matter or procedure, and there's a lot of internal discussion. I am working on that, but yeah,
So if you start at the middle, then a 2-day suspension seems awfully low.
it is. It's a lot of mitigating to get to that level.
which is also, Kathy, why we get sometimes wrongfully and sometimes rightfully blamed for being a little all over the place with our discipline as well too. And I do think there is something in terms of a clear expectation and consequence that an officer needs to know that, like, okay, they're gonna be started. If I mess up, they're gonna be started from this point on. And it's not like, oh, well, if Riles gets the case one day, it's gonna be 15 days. And if Ricardo gets it another day, it's gonna be 30 days, right? It's just like there needs to be a little bit more of a kind of a track and template of and how we institutionalize what the practice is that we actually follow in some of these cases. Because again, I agree that if a cop has a stellar record, 0 complaints, great personnel file, it's been on the force for a while, and so happened that, he came to work and his breath smelled like alcohol, and this became an issue, right? It was the first time he ever had anything in his file, right? It actually, like, in my opinion, it wouldn't feel right to start at the middle of 17 days, right? Because it's like, damn, it was a very minor infraction, and now you're starting at 17 days, which is also why we looked at on some other MOR violations a class 2 consideration, so that we could actually take into account more of a procedural misstep. Whereas in this, I don't see a class 2 being appropriate, because like drinking is drinking, like that. There's no like procedural misstep in that. But I could also see how if an officer has a stellar record, they're a great officer, they have nothing in their personnel file, and it's this one hiccup, starting at 17 days actually does feel a little higher, which then a cop will go and file a grievance or arbitrate or contest it on the back end. And then that's how we get held up with officers being on leave for so long as well. So I think that if we could all maybe agree on what we're seeing and what that practice is, and maybe folks on the back end would be a little bit more accepting of their consequences, and that there, my friend, would be a true indicator of culture change.
Yeah.
But isn't during those discipline meetings, isn't there a part where they're supposed to pull up records related to the same offense? And yeah, so it should
5
be
years,
all
right,
over
Captain?
the place.
5 years, yes.
Yeah. But with
Right?
the starting points is what's being contested right now in terms of like what that practice actually looks like.
Oh, okay.
So are
And
people
the funny thing is, every time we've asked, like, well, where does that middle part even come from? It's the answer is from everybody is always like, that's just how we always did it. I don't know where it came from. I don't know where that's written at. I mean, I don't know. So there's just a lot of ambiguity around that. So again, we just want to disarm any narrative that could make us look like we're all over the place and that discipline is harming our police department. We want to get rid of those narratives.
So are people comfortable with the starting point to be 2-day suspension? Audience?
I don't have a problem with this one.
I don't have a problem with that. No, that's fine.
Yeah.
But I have a question. How do you give them a breathalyzer test to determine, or is it just the smell test? How do you determine whether someone is impaired and impaired to a degree or just impaired, period?
Right, because you have functional alcoholics who can actually do their job, and you just
Yeah, so that's why so even if you're functional, I would like to know that there is
They are
a test.
Well, it would have to be a compilation of things. It couldn't just be the smell. It would have to be whatever behavior that drew your attention to them. It would have to be like slurred speech, stumbling when they're falling down, like Captain Hubbard said, belligerency, creating a disturbance with other employees, that drew their attention that, you're under the influence.
Yeah.
And you don't have to be, so impaired that you can't drive a vehicle. You just have to show up to work and you're impaired. And it can't just be alcohol. You know, it could be pills, it could be other things that have no odor to it.
But then my question is, again, you're looking at physical manifestations, if you will, of intoxication.
Yes.
Is there any test? Is there a breathalyzer test?
I think that would be one thing I would use.
We can, yeah.
Oh, just
that would
one
be one
thing?
of them.
But wouldn't you want to do that always? If you're going to charge them with being impaired?
I wouldn't have a problem with doing it always. I would, but I don't know. If you refuse to take a breathalyzer exam while driving a vehicle, you can lose your license and be taken into custody. That's implied consent. But you don't have any implied consent at a police department.
I'm a little perplexed, especially, the functional alcoholic. And it's not so much something you could smell like vodka or gin or whichever one of those doesn't have an odor.
Right. And, there's no absolute in this. It has to be a complement of several things that you observed, that you described, that may mean that the person is impaired and under the influence of some intoxicant, not necessarily alcohol. Doesn't have to be alcohol. He could have taken some pills or something that are odorless and colorless, but he's stumbling around and slurring their speech and being belligerent and falling down or doing some other embarrassing thing that the person is obviously under the influence of some intoxicant. You have to be able to describe that. And everything could be different. And of course, you got certain folks, merchant marines and sailors that are used to walking on rocking ships. They can handle their alcohol. And that's just the way it is.
Yeah.
It just, there's no cut and dry situation here. I think we ought to be looking for it. And that's the best we can do.
Now, I would say though, if they are a functional alcoholic, there's no signs of impairment, they're doing their job just fine, but their breath really reeks of alcohol. I
That's a
mean,
problem.
that's a problem because we're
Yeah.
customer service, right? You're talking to
Exactly.
people, you're taking reports, and you can't be having your breath
That's
smell
the
like
problem.
alcohol. Yeah,
That's the
so
problem.
for sure. But I think in terms of just the MOR itself, the way it's written, it's pretty. I mean, looks pretty straightforward to me. You guys have any input on this?
No,
Things are
I'm
good.
good. No more.
I was just wondering, I don't think everyone answered, and I guess everyone doesn't have to answer, but if we were comfortable with the lower end being a 2-day unpaid suspension.
I got to take this call, y'all.
Okay, well,
Y'all might not see me back.
Yeah,
Give me a
I'm thinking
second.
of the guy that comes to work and, you know, and he probably should have stayed home because he has a flu or something and he's taking some cough syrup
yeah,
that has a bad reaction.
yeah,
So I want to give them enough room in there to say, well, you probably should have stayed home,
right.
but we understand you're sick and you came to work, so we're not gonna hit you with 17 days off.
Yeah,
Well, that's a good example.
Yeah.
yeah.
But why did we jump over physical fitness for duty? Because it's a difficult one to deal with? Or?
No, we're not going in order. I'm going by termination first, so we're gonna get.
Oh, okay, I got it.
Yeah,
I got it.
yeah,
Okay.
we're gonna
I
get
apologize. All right.
there. Yeah, it's all good. Okay, I think we're at 7:30 now, so I appreciate everyone's time. I am going to
See you in
make
a
a
couple of
note
weeks.
that we left off here, and I know my deliverables, and we'll see you in a couple weeks.
okay.
Take care, guys.
Thank you.
Thank you.
Have a good
Bye-bye.
evening. Bye-bye.
Bye-bye.
Hey,
Well,
Bye,
let me
everybody.
just say, so we're every third Wednesday, or
Every first and, yeah, everything. I'll
Every
send it to you.
third?
I think it's every first and third, but it could be, I've got so many ad hocs. Let me follow up with you, Kathy.
Okay.
I think it's every
Thank you
first
all
and
for your
third.
input.
Thanks, everybody.
Bye-bye.
Thanks. Bye-bye.
bye, everyone.
Thank you, Micah.
You're welcome. Bye-bye.